role of the judiciary in the war against graft, and I want to specifically talk about the Galadima panel, which has been inaugurated by the Chief Justice of Nigeria. Justice Salami, in refusing the leadership of that panel, raised certain issues. First, on composition, and two, he thinks it would amount to a waste of time because you can't tell the mind's construction from the face, especially as the panel members will not be there when the judge is writing his judgment. He really doesn't think that the panel is necessary. What do you think?
I think we have to start by congratulating the Chief Justice of Nigeria for ordering or directing every court system to set up a division to try corruption cases. That is a major achievement on the part of the Chief Justice. It's, what word shall I use? In a sense, it's like going to the moon, you know, in terms of anti-corruption war. It's a great leap forward. So he's to be congratulated. It's a major development.
And that's something that you've advocated in the past.
In fact, we have a bill before the National Assembly which is not moving. So it's a very great achievement. We have to congratulate him. Now, he then went further to set up a monitoring committee that is going to monitor what these judges, these specially selected judges, are going to be doing in their courts, so that reports can be written to the NJC to allow them determine whether those judges are living up to expectation, whether they are meeting all the provisions of the Administration of Criminal Justice Act. Again, brilliant idea. Brilliant idea. It's to be praised for it. Now, the devil is in the details. The detail in this case is including the MBA president and former MBA presidents in the monitoring committee. I think that's where things got wrong. You see, because these people, amongst these people are those currently defending high-profile looting defendants. Amongst them are those who have done it in the past, whose case, the case he was handling, was responsible for the removal of Justice Salami from the presidency of the Court of Appeal. Because the then Chief Justice of Nigeria illegally and immorally and unconstitutionally approached Salami to intervene in a case concerning Sokoto state governorship, which was believed was going to end in the ouster of a favorite government candidate. He refused. And they were so desperate to get this illegality done, that is, intervene in the case, that they attempted to promote him to the Supreme Court so that they can get a compliant person in the Court of Appeal to do it. He refused to be promoted. Promoted, in fact, kicked upstairs. This is really what they wanted to do. And for that reason, they suspended him. Not only that, that case, which was meant for the Court of Appeal, because at that time, Supreme Court had no jurisdiction over governorship cases. It ended at the Court of Appeal. The Supreme Court now violated the Constitution, took the case upon itself, dismissed the action of the unfavored candidate in order to save the favored candidate. So a major illegality was carried out by the Supreme Court. And as I said, one of the lawyers who is now being asked to be in this committee was a lawyer to that candidate who was favored. And you can't really say he had no hand in what happened. So you can see that the whole thing is a non-starter with people like that. Not only that, some of them are actually currently handling high looters cases in the courts. Others have handled in the past. You know, these things create a state of the mind in which they begin to see these high looters as people who are worthy citizens, worthy to be defended. And not only that, They have even created a profession within the legal profession, specializing in defending high looting cases. They introduce obstructions, frustrations, adjournments, traveling overseas for medical attention. To summarize it, frustrating these cases, some cases have lasted 15 years, and to go up to the Supreme Court and come back. And these are the people who are now supposed to be monitoring whether corruption cases are being handled effectively, efficiently, and speedily. Obviously, their culture is against the very thing they are supposed to monitor, and they will subvert the whole process.
What about the arguments that they're professionals and they're merely doing their jobs?
They are professionals who have specialized in a subspecies of litigation, defending looters. They are oriented towards that. Their sympathies are towards that. They can never be objective in matters like this. That's number one. Number two, these are the titans of the legal profession. Senior advocates, some of them decades as senior advocates. Now, if this man walks into a court, do you think the judge will behave normally? The judge will become an actor. He will do what he thinks will please the senior advocate. He will become artificial. In fact, the whole thing will become a stage, not a proper judicial proceeding. So, it's going to ridicule the whole process. Rather than do that, in fact, even if they didn't have this background of defending looters, senior advocates are not the best people to do this. My own view is that the CJN should recruit young lawyers, less than 5 years old, not known, anonymous, who will sneak into the court quietly and sit as if they are not the lawyer's bench, sit where you have litigants, mixed with the litigants, dressed normally, shirt and trouser. Then nobody will know they're there. And then they will listen to the proceedings, they will take notes, they will now begin to check whether the judge is going to adjourn to write a ruling on an interlocutory application, which is a breach of the Administration of Criminal Justice Act. They will check whether the judge is sitting from day to day or is adjourning cases unnecessarily, which is another breach of the Administration of Criminal Justice Act. They will check even if adjournment is inevitable, that adjournment is more than 14 days, which is also a breach of the Administration of Criminal Justice Act. They will again check whether when any person decides to appeal on an interlocutory matter, the judge is going to stay the case, which is not allowed to do under the Administration of Criminal Justice Act. Finally, they will also check whether if the judge is promoted in the middle of the case, he will hand over the case and go to the higher court, leaving the case to be tried de novo, which is again a breach of the Administration of Criminal Justice Act. These are the things they will do. Only small lawyers who are not known or civil society groups who are not known by the courts can do this effectively.
Finally, Prof, I know that PACAC, the Presidential Advisory Committee Against Corruption, is an initiative of the executive, and the Galadima Trial Monitoring Committee is an initiative of the judiciary. But when you look at the end goals and the larger picture, and you think about the fact that they are both service to the nation in winning the war against graft, are we likely to see a collaboration between the two committees? And if yes, to what extent?
Oh, the minute the Chief Justice announced it, PACAC wrote to congratulate him and offered to partner with him in this new endeavor. And in that regard, what we are planning to do is also to set up our own monitoring group and to then compile their reports and send to the NJC, over which the Chief Justice of Nigeria presides. So we are partnering with him. We are very happy with him. It's a great achievement. It's to be congratulated. This little matter of composition of the committee should not in any way detract from the major achievement of this Chief Justice. And it can be cleared, it can be solved easily by just asking those people to live quietly and allow justice to move on without any distraction, which is what they are.